Okay, since we covered the history of law, let's start the discussion of this section with the elements necessary for laws. Slide 14, we need authority, someone who has the power to make laws, and in the United States, it's primarily legislatures and both state and federal. We also need a legal code or a body of written laws. And finally, we need a legal system to carry out the laws. In other words, police, courts, and corrections. Why isn't this moving? There we go. There are positive and negative aspects of law. The law's positive functions include the items listed on the left side of this slide. Primarily, the aim of the law is to keep the peace and promote justice. There are also negative aspects of the law. It can divide society. Some people want the laws changed, and others want the law to remain the same. Right to life issues, national health care, etc. These are some of the issues that people fight about. Some say the law exploits people. For example, making everyone buy health insurance could be considered exploitation. Back in the 1940s, people were very much against Social Security programs. Now the government is debating to repeal affordable health care, and the public is against it, even though they fought against having the law in the first place. Does the law exploit young black men, tenants, landlords, etc.? Do the laws and the legal system favor the wealthy and their happiness? Some say it does. So who makes the laws? We covered this one earlier in earlier lectures when we talked about who decides what's crime. Actually, we didn't do that. Who decides if something should be a law? Well, Congress, state legislatures, and cities, as well as certain jurisdictions, such as certain types of businesses that are regulated by law, for example, environmental law. As with crime, the law reflects the current state of society, although the law is usually behind the current thought. Occasionally, the law precedes social change. An example of this is handicap parking and laws that require making public buildings available to handicapped persons. Do we have too many laws? Good question. Some would say we do. The legal field has become a growth industry. The feds and states add over 150,000 laws to the books every year. More laws mean more lawsuits. More lawsuits mean overburdened court system, which may or may not mean a less effective legal system. We all expect the law to help us, but does having so many laws make life more difficult, more complex? The legal system is a bureaucracy, and like any large bureaucracy, it can become more concerned with the rules than with meeting the needs of the people. Alternatively, in a country this large, not having laws would be chaos. Our legal system In our legal system, we have four types of laws: substantive, procedural, civil, and regulatory or administrative law. Oops, let's see, I think we missed it. Substantive law is the letter of the law, and here we're referring to criminal law. These laws prohibit certain behaviors like murder, robbery, etc. Substantive laws are for keeping the peace, social control, and deterring criminal behavior. Procedural law tells us how to administer these substantive laws. In our system, procedural law focuses on the accused. The Miranda warning is an example of procedural law, stating what must be done when an arrest is made. Most procedural laws are in the Bill of Rights. However, some procedural law can be found in state and federal statutes, state constitutions, and federal and state rules of procedure. You can find these procedural rules in the Federal Rules of Criminal Procedure. Most states have the equivalent in state rules of criminal procedure books. Crimes are violation of the penal code, which are laws pertaining to a specific jurisdiction, such as interstate commerce laws and city ordinances. A violation of civil law is called a tort. Civil laws relate how conflicts are to be resolved between individuals. Laws governing landlord-tenant relations are civil laws. Another type of law is common law. I think I think I missed we're on the wrong slide, and I've got a dog who wants attention. Okay, crimes are violation of penal law. Another type of law is common law. We've covered common law when we talked about mala in se and mala prohibitum laws. Precedents determine these laws. When a judge rules in a certain way, his ruling becomes case law. I think it's the next slide. Here we go. Case law, and can be used in other trials by other judges. The principle of stare decisis pertains to common law. Stare decisis means let the decision stand, meaning that a precedent will not be countermanded. The last type of law is administrative or regulatory laws. Common law. Okay, here we go. These are not really laws, but rather rules that set guidelines for businesses and practices. The administrative or regulatory agency is authorized by legislative bodies, and they create rules that have the force of laws. Violations are handled either by the authoritative agency or by civil law proceedings. Occasionally, laws are prosecuted under criminal laws. Such examples of such agencies are Federal Trade Commission, Federal Communications Commission, Nuclear Regulatory Commission, DEA, Drug Enforcement Agency, OSHA, Occupational Safety and Health Administration. Decisions made by these agencies are addressed through civil court procedures. However, legislatures can enact criminal laws based on recommendations by these agencies. This next slide shows the result of environmental laws enacted over the last 4 decades. They look pretty different, don't they? Now that you know the types of laws and who makes the laws, what are the features of good laws? Primarily, we're talking about criminal law here. There are 5 components of good laws. They are: the rule of law or law must be made by the agency with the authority to do so. The law must be specific and prohibit specific behavior. The law must be applied to all persons regardless of their status. And the law must be enforced equally to all persons, and there must be legal sanction or punishment. That last one is really important, that if the law doesn't have a specific sanction, then it's not a law. Okay, that's it for this lecture.